from for the state and council.
Sentongo Timothy Ebo for on watch brief. Council.
Ese worship kakuru tumusime. I appear together with Sewal Alan and Nsibuka Haruna. Worship, we jointly represent the accused person. Yeah, Your Worship, this matter is coming up for a ruling on a bail application.
The ruling is ready.
And we are ready to receive the ruling.
Benefit of hearing from all the parties in this application for bail. Indeed, it's the right of accused person to apply for bail. The grant of the same is that subject to discretion of court. Appreciate the submissions of both the prosecution in opposition to the bail application and the defense in support of the application. I need not to produce the submissions in this hearing as they are already captured from the record of the court. I have evaluated the submissions and weighed them against section 75 7 of the Magistrates Court Act. The bail guidelines. Grant of bail is subject to applicant fulfilling some conditions. The offence accused is charged with. Offences accused is charged with are all eligible for offences by this court. She has presented two sureties. Land State has objected to the said sureties among others. The sureties are Namtu Madina Matoju and Burega Mohammed residents of Burama, Setam, Municipality, Shibando Central, Urban Council, County Division, respectively. While I appreciate the two sureties, it is my opinion that the justice of this case will demand more than two sureties. I note that this is a resident of Chitukute, Chira Commission, so district. Consequently, I'm unable to decide the discretion within the context of this case to grant bail to the accused person with only the current two sureties. It is so obvious. Council, I hope you have understood.
Yeah, we appreciate the ruling, Your Honor. And Your Honor, we request for a copy of the ruling. And Your Honor, we also have an issue to raise before this court. Your Honor, since the accused person was arraigned before this honorable court on the 14th of January 2026, Your Honor, this is coming to a month. However, for all this time, the accused person has never seen the complainant in this court. And Your Worship, it is under section 117 of the Magistrates Court Act that mandates or commands the complainant in any criminal case to always appear in court as and when the matter comes up. Your Honor, the consequence of failure by the complainant to appear in court under section 119 of the Magistrate act is that this matter ought to be dismissed for want of prosecution. One of the purpose of that directive is for a fair and speedy trial of the accused person. And even today, Your Honor, I'm not seeing any complainant in this court. Is there a complainant in the court? Your Honor, we have no complainant even today. So, it is my prayer and in the interest of justice, in respect of presumption of innocence of the accused person and her personal liberty, that this court be pleased to dismiss this case for want of prosecution on that ground. Because, Your Honor, we might be here when the accused is still on remand, and maybe we don't have any person complaining in this matter. Further, that up to date we have not had any disclosure. So we risk our client being in jail for longer than expected, and maybe unfounded allegations. You know, my colleague is going to address court on the issue of jurisdiction, which we also want to address, and I invite him to take on.
Your Honor, for the record, Sibuka Haroda. Your Honor,
Just a moment. The name?
Sibuka Haroda. Your Honor, premising our submission on the continued detention of the accused person, we are provoked to question the jurisdiction of this honorable court to entertain this matter. Your Honor, jurisdiction is a breach of statute. And the Magistrates Court Act requires that accused persons must be tried by courts where the offenses were committed, Your Honor, all omitted. Your Honor, looking at the charge sheet, the accused person, Your Honor, is a resident of Kira in Wakiso. By presumption, courts of Wakiso would entertain the matter. But Your Honor, as if that is not enough, the complainant also resident of Chiwatule, which falls under Nakawa, Your Honor. And Your Honor, it beats our understanding that the complainant in the charge sheet alluded that the offense was committed in Chiwakis. If this honorable court does not invoke its mercy, to look at the legal occurrence in this case, will be putting itself in a very difficult place, looking at the continued detention of this innocent accused person. You know that the accused is still presumed innocent. He is innocent, and it is coming to 30 days incarcerated. Your Honor, a complainant has never surfaced. If it is not this type of justice, look at that. Then who? Your Honor, we pray for the interest of justice. This is a court of justice. We pray that this matter is dismissed for want of jurisdiction. We so pray, Your Honor.
I'm here because it's not time for hearing. We shall summon her when the case is set for hearing. Scholarship on the issue of jurisdiction. We have files which were sanctioned where the subject matter happened in Chiwato, and they still bring them back. Your Chief, on the issue of disclosure, we do it at the expense of the accused person. Your Chief, we are ready even today to disclose if they pay for it. Stewardship, still on the issue of jurisdiction. Cyber crimes stewardship are offenses committed on space. So section 175 gives a magistrate.
The what? Which law? Which act?
MC.
The MCA, Your Worship. To handle any case of that nature. That's okay,
Your Honor, I want to rejoin briefly on the issue of jurisdiction as replied by the state.
she says that they have quite a lot of files that are sanctioned in Chiwature but are hard from here. Your Honor, that is wrong. That is not what the law says. That is exactly what we are objecting to. The fact that they are hard from here while sanctioned in Chiwature doesn't make it right. It is very wrong. You can't vacate the provisions of the law. Like my colleague submitted, Your Honor, jurisdiction is a creature of the law. You cannot simply vacate it because many files are sanctioned from Tira and hard from here. Those accused persons in those files, Your Honor, are not complaining. They have not raised these issues before court. And court cannot raise them for those particular accused persons. But for us, Your Honor, we have observed it and we are bringing the same to the attention of court. It is not right. If a matter was committed in Chiwature, we all know territorial jurisdiction, Your Honor, Chiwature must be falling under Nakawa. And we are saying this matter should not be heard here. Yes, in fact, I'm being guided by my colleague. If you have been doing it, you should apologize for the same. Because, Your Honor, it is not right. Your Honor, it even puts a bad image on this honorable court. Because the question that is coming up is, why is it that a matter that is in Chiwature, that is supposed to be in Nakawa, is being heard here? It somehow, Your Honor, creates an impression.
I don't know whom she should apologize.
So, Your Honor, our issue is, Your Honor, finally, on that issue, our issue is this court has no jurisdiction to handle this matter because the charge sheet is clear. The offense was committed in Chiwature, and therefore this matter should fall under a different court. My colleagues will take on.
Yes, Your Honor, Kakuru Tumsime.
You say the matter is supposed to be which court?
Nakawa. Not Stewart. Your Honor, I will start with the particulars as provided on the charge sheet by the state. The particulars say that the offenses were committed in Chiwature.
The name is Kakuru
Tumsime, Your Honor. The offenses were committed in Chiwature by territorial jurisdiction of magistrates' courts. It is outside the jurisdiction of Sotebor. Yes, Your Honor. I wanted to clearly bring out the particulars as recorded in the Your Honor, also section 119 of the Magistrate Courts Act is clear, and it does not only allow the complainant to appear when he is testifying. It is clear in terms that the accused must appear in court as and when the matter is called up, not only to testify. The complainant, rather, must appear in court as and when the matter appears. It's not about whether he's going to testify or not. But the unfortunate bit of it is that the accused person doesn't know the complainant. We might be faced with the incidences or scenarios where aliens are now starting to complain and accused people are being remanded to Luzira. It is so unfortunate for us. So, Your Honor, the effect of failure of the accused, of the complainant rather, is that the matter should be dismissed. And Your Worship, it is couched in a mandatory term, shall be dismissed. Maybe if I may read the part.
I will read it.
Okay, Your Honor. So I will invite my colleague to address you on the section 175.
Your Honor, as we conclude,
I forget your name.
this Sibuka Haroda, Your Honor. Your Honor, the Lord State has quoted, has misguided this honorable court by quoting a wrong law, section 175 of the Magistrates Court Act, which he asserts that this honorable court has jurisdiction to entertain cyber crime matters. Your Honor, this section is specifically on conviction after convicting the accused person. And verbatim I can read section 75, Your Honor.
No, you don't. You said
175.
I'll read it.
You read.
175.
So, Your Honor, we invite this honorable court to dismiss that section. It is misleading this honorable court. Your Honor, as we conclude, justice should not only be done, it must be seen to be done. For want of jurisdiction, we pray that this honorable court dismisses this matter, and for want of prosecution. It's okay.